Robyn Hollander is an Associate Professor and Head of School at the Business School at Griffith University. She has a long-standing interest in federalism and regulation and has written and researched extensively on these issues. She has published in numerous highly regarded journals, including Publius, the Australian Journal of Political Science, the Australian Journal of Public Administration, and the Australian Journal of Politics and History. She also edited and contributed to a number of important texts in this area. A particularly fascinating question, which has gained considerable attention in the United States in recent times, and then here, concerns the links between federalism and moral policy. We're particularly lucky to hear her speak this morning on the topic of morality, policy and federalism. So please join with me in welcoming Ms. Hollander.
Thank you, Eddie, for such a warm introduction, and thank you all for the opportunity to talk to you about one of my areas of enthusiasm, interest, and it's great, in fact, to have a new audience. I think I've bored all the political scientists to death. This question arises in part out of my interest in duplication and overlap, federal duplication and overlap in politics and policy making. They are, duplication and overlap, high on the list when considering the limitations of a federal system. Economists despair at market inconsistencies. Lawyers, and I hope I'm not assuming, express frustration when confronted by legal anomalies. Citizens rail against variations in everything from school starting ages to road rules and professional regulation. These largely practical concerns can overshadow a more abstract, more principled concern, the capacity of duplication and overlap to undermine rights, particularly in areas of personal and social morality. And this is the starting point for my talk today. The question I'm asking is the duplication and overlap that characterises many federations, including our own, as dysfunctional and unprincipled as it first seems? And in particular, what does it mean for morality policy? To answer this question, I'm going to survey some of the arguments before examining a single policy area, that of same-sex marriage. And here I'm going to compare the US experience, which is characterised by duplication and overlap, with the Australian experience, which to a large extent is not. But first, a few definitions. As we all know, duplication and overlap characterise all contemporary federations, or almost all. Duplication exists when, and this is my trying to be more systematic, exists when multiple jurisdictions have the same roles and responsibilities, while overlap occurs when jurisdictions share roles and responsibilities and therefore have the capacity to affect the policy space in some ways. And this can be directly through legislation or the courts, or also more indirectly using financial incentives, other powers, even agenda setting. Okay, so that's duplication and overlap. What am I talking about when I talk about morality politics? And here it'll become clear that I'm not a political philosopher, because I'm going to draw on the public policy literature, which defines morality policy quite simply, drawing on observable criteria. Okay, so what are the characteristics of morality policy? First, and most importantly, morality policy deals with issues of first principle, issues of right and wrong, good and bad. What's significant about that from a policy-making perspective is that it means that morality policy exists the technical incremental compromises that characterise policy-making in other domains. We can negotiate about the appropriate level of corporate tax. We probably all agree that some taxing of corporations is appropriate. But the death penalty, as another example, poses a far greater challenges because we are either for it or against it. You can't be half for it. Thus, around this contested issue, there can be no substantive compromise. Secondly, issues of morality policy have a high level of salience. They are easy to understand, and because of this, most, if not all people, have a view. Everyone has an answer to the question, do you support euthanasia? Or are you in favour of legalising cannabis? Morality policy can therefore be said to be inclusive, and this leads us to its third characteristic. Morality policy generates higher than usual levels of citizen involvement. Because the debate revolves around basic value questions that are relatively simple to grasp, those who are usually unmoved by politics will be more willing to form an opinion, expound a point of view, or even act politically. We can take the high-level engagement in the same-sex marriage vote as an example of this. Now, why then does duplication and overlap matter to morality policy? Well, if we canvass the arguments, to put it bluntly, to universalists, it's an abomination. For them, federalism is an institutional form that has allowed the perpetuation of gross injustice. We just have to think of the recent marriage of an 11-year-old girl in the Malaysian state of Kelantan. The marriage itself was legal under state law. The man was fined because he was found guilty of polygamy, not marrying an 11-year-old. That's a recent example, but examples of state-based injustice have a long history in the United States, where critics have long contended that federalism is in fact indelibly stained by slavery, by Jim Crow, and by more subtle forms of racial discrimination, all justified by a commitment to states' rights. Here in Australia too, we can point to examples where states have enacted policies in line with particular moral codes and imperatives that constrain individual rights. Policies around prostitution, censorship, state education, around rights to life and death, recognition of relationships, right to self-determination for Aboriginal Australians. The only way to avoid such outcomes, say the universalists, is to concentrate all responsibility in the hands of a central government which will be less easily swayed by minorities and better able to legislate in areas of morality. But such an absolutist sort of formulation provides no guide to policy making in areas where moral principles, principles of morality, collide. Rights to life versus women's rights, physicians' obligations to preserve life versus individuals' desires for assisted suicide, religious freedom, same-sex marriage. In such areas, there's no clear path, and I'm going to argue it's here that federalism, and in particular the duplication of competencies and overlap, the sharing, provide a way forward. And this is because duplication allows individual communities to resolve such questions in ways that line up with their dominant value set. And for the duplication discussion, I'll be drawing on the work of Christopher Mooney, a US political scientist. Mooney argues federalism is well suited to the formulation of policy because in a policy with heterogeneous values, and he's using the US, but we could also argue about Australia, and I've done some work there and I can talk about that. In the individual states, we are more likely to find homogeneity. And there, individual states can design policy that largely conforms to the preferences of the citizens. He then says this explains long periods of dormancy in policy making in really contentious areas because of that alignment between citizen preferences and the local policy making. Change only occurs then when community values shift, and until then politicians are content to let sleeping dogs lie. Even a vague whisper of change make them nervous because it can open up the space for policy entrepreneurs to try and shift policy settings to align more closely with their preferred preferences rather than those of the community. For Mooney, duplication is federalism's virtue. It allows every state, every province to resolve morality policy conflicts in their own ways. Overlap for him, the twin, is, for Mooney, it's cursed because it disrupts this state-based resolution. And for him, overlap paves the way to one of two outcomes. Either ongoing conflict, and here he cites abortion in the US, where, and to quote, federal usurpation of state authority on morality policy has led to extended, acrimonious and irreconcilable policy activity. Or, and here he talks about the death penalty, state-based resistance, a steady undermining of national determinations. And he says, well, look at the death penalty. In 1972, it's rolled back by the Supreme Court, it's met with state opposition and undermining, and rolled back just 4 years later, allowing a measure of what he calls policy congruence to be re-established. But what happens when public sentiment moves ahead of our federal, state legislators and courts? And this is a question I want to turn to now. And here I'm going to argue that it's the combination of federal duplication and overlap that provides a better framework for dealing with morality policy challenges than either state or federal exclusivity. And I'm going to do this by looking at the same-sex marriage debate in Australia and in the US. As you all know, in Australia, responsibility for marriage is characterised by an absence, largely, of duplication and overlap. And I'm going to argue that this lack of duplication and overlap means we saw a significant gap develop between public values and political action. And the misalignment was evident, I think, in the high level of positive engagement in the results of the 2017 same-sex marriage postal survey. Nationally, 62% of respondents favoured legalisation of same-sex marriage and only 38% voted against. And there was majority support in every state and territory, although there were significant differences, and I'll come to those a bit later. Now, the absence of duplication and overlap. As we know, primary responsibility for marriage rests with the Commonwealth. Section 51, 11 is marriage, and 12 is divorce and parental rights. The Commonwealth had steadfastly refused to recognise same-sex marriage over a number of years. In fact, in 2004, it passed the Marriage Amendment Act, which defined very explicitly marriage as a union between a man and a woman. Amendments proposed in 2009, 2010, 2012, which would have recognised same-sex marriage, all failed. At the same time, however, and this is important to my argument, some states were busy legislating in the area. While primary responsibility for regulating relationships lies with the Commonwealth, the states have indirect engagement. Historically, prior to the establishment of the Federal Family Court in 1975, the state courts heard divorce cases. They dealt with child custody until the 1980s and still do, as I understand it, in Western Australia, and they maintain the marriage registries. Also, prior to 2009, the states were responsible for de facto relationships, including partner rights and property, and this aspect provides an avenue for many to involve themselves in the recognition of same-sex relationships. Between 1999 and 2006, 7 of the 8 jurisdictions extended their de facto arrangements to cover same-sex couples. The Commonwealth followed in 2008 when it removed all discrimination against same-sex couples in relation to taxation, superannuation, social security, health, immigration, citizenship and family law. But several subnational jurisdictions, several states went further, and territories. Between 2003 and 2011, Tasmania, Victoria, the ACT, New South Wales and Queensland all introduced legislation that provided for the formal recognition of same-sex relationships. In some cases, this amounted to simple registration, but in others, there were provisions for ceremony, celebrant, certificate, as well as access to adoption and provisions for revocation. It was, I think we can agree, for all intents and purposes, marriage light. 3 states, or 3 jurisdictions, tried to go even further. In both Tasmania and New South Wales, same-sex marriage bills were introduced into the Parliament, and while it's doubtful if these had much chance of succeeding, the ACT was more ambitious. In 2013, it passed its Marriage Equality Same-Sex Act under which 31 couples married before the Act was disallowed by the High Court. Unsurprisingly, the ACT recorded the highest level of support for same-sex marriage in the 2017 vote, followed by Victoria and Tasmania. In this case, this evidence suggests that the absence of duplication and overlap meant there was a mismatch between community values and policy settings in some Australian jurisdictions at least. And arguably, the postal vote showed that, overlap would have been helpful. Now I want to turn to the United States, which offers a contrasting story. In the US, responsibility for marriage is characterised by duplication and overlap. The states have primary responsibility for the key elements of marriage, ceremonies, obligations, divorce, and so on. Federal involvement is indirect through child welfare and support, domestic violence, economic regulation, immigration, citizenship, and importantly, civil rights. This has essentially meant that the states have been free to chart their own route through the same-sex marriage debate, beginning in 1991 when Hawaii allows same-sex marriage. This first foray was quickly overturned by legislation and then more permanently blocked by constitutional amendment in 1998. But in the 2000s, we started to see same-sex marriage provisions occurring first in Massachusetts in 2004, then Connecticut in 2008. Between 2008 and 2013, another 15 states plus Washington DC had followed. As is the case in the US, each proceeded along its own route, many via legislation and several as the result of judicial decisions. Interestingly, these changes were not necessarily organic. LGBTI activists, the policy entrepreneurs of the story, targeted states and cases where they had community support as well as a strong chance of success. In other states, perhaps a reflection of the prevailing community values, same-sex marriage was decisively rejected, often through constitutional amendment. State-based bans ranged from simply targeting same-sex marriages to civil unions to any marriage-like contract. In this case, federal duplication allowed states to chart their own individual paths. But as we know, the story didn't end there. In 2015, in a landmark ruling, the US Supreme Court ruled that all states would be obliged to licence marriage between two people of the same sex. The court based its decision on the 14th or Equal Protection Amendment of the Constitution, a clear result of overlap. Mooney predicted that if this sort of overlap contravened community values, we would see ongoing conflict or state-based resistance, especially where there were significant differences between states. Survey data suggested this might be the case. Survey data collected just prior to the case showed wide variations in support, ranging from 75% in favour in New Hampshire to only 32% in Mississippi and Alabama. Despite this, and I think interestingly, thus far opposition has been relatively muted. There have been a few cases involving the providers of marriage services, bakers, florists and the like, and discussion of using freedom of religion provisions more extensively, but we've yet to see the concerted backlash around the marriage provisions at least. Perhaps this is because there is increasing support for same-sex marriage across the US. A 2017 Pew Research Centre survey found that 62% of Americans supported same-sex marriage, up from 35% in 2001. And unfortunately, these figures weren't broken down by state. But what can we conclude? I think we can all accept that there are areas of morality policy where values clash. And I have argued, I hope persuasively, that this is where the bête noire of federalism, duplication and overlap, can offer a way forward. This is because it can allow a better alignment between community preferences and policy settings. Thank you very much.